Welcome everybody, and I don't know how many of you there are, but we're really happy to be here today. As Rodney mentioned, I am the president and Shannon is our head of operations for the Rights Company. We are a rights research and clearance company based out of Toronto. We have an office in British Columbia as well. But we have basically do, as many of you may know, script clearances, intellectual property clearances, title clearances, and design clearances for film, television, video game, web-based projects. And just to give you a little bit of 411 about ourselves, we've been in business since 1998. We started, and we're not lawyers, we're researchers. Our reports kind of work in conjunction with your lawyer. And I just want to go through the breakdown of what we're going to cover in the next 50 minutes, an hour, and then I'll jump you over to Shannon and she can give you a rundown of the different reports that we do, what they involve, and why you need them. And then we'll get into more the types of clearances that you sort of need to keep in the back of your mind when you're working on a project, and the layers of clearances that you should think about when you're incorporating things into your project, or you're creating things for your project, or you're licensing other people's works for your project. So I'm going to throw it over to Shannon. She's going to kick off what our main services are and why you need them, and then we'll come back and get into the nitty-gritty of clearances. And I just want to say, if anybody has any questions, just jump right in, and we'll try to answer them as we go. We can stick around afterwards if you have any questions. So there you go. Shannon?
Hi, everyone. My name is Sharon Hancock. I'm the head of operations for the Rights Company. I'm just going to go over the different types of reports that we offer. We offer 3 types of reports. They are the script report, the title report, and the design report. So I'm going to just go over kind of each one and what it involves. A script report is a report that is a research document on your script. It includes searches on fictional names. So we have many different databases that we search. Any type of name in your script that is fictional, so characters, businesses, fictional song titles, magazine titles, anything like that, as well as unique phrases we also search. They will all appear in our report. We do in-depth research on all of those. The report will also cover anything that you that is real that you might mention if you need permission to use or to mention. That'll be in the report as well. So if you're using a song, or a Coke bottle is shown on screen, or a character's walking into a room carrying a McDonald's bag, things like that will all be flagged in our report as well. The report is required for your insurance company. So once you get that report, your lawyer would go over it with your insurance company, and they'll kind of make the final decision on what names are fine to use and maybe what names you might need to change based on the information that's in that report. The second report that we're going to talk about is the title report, which is a very, very in-depth search of the title that you want to use for your project. We search about 120 different databases, not only film and TV, but songs, books, headlines, magazines, toys, games, apps, just all kinds of things, as well as trademarks in many, many different countries are covered in that report. And then the other big part of that report is a copyright search in Canada and the US. It's a very in-depth search that pulls out anything from the Copyright Office that has the same title that you're proposing to use, and that would all be included in there as well. And again, that's a report that goes to your lawyer, who would decide whether or not the title is okay for you to use or not. And that is based on how many titles there are, if there's anything coming out in the near future with the same title, and also if the content is similar. Those are the types of things that may be a problem for that. The third report we have is a design report, and this is one that isn't required by your insurance company, but some of our clients like to use them just as kind of an added layer of protection. And a design report is for things like animated characters, anything else in an animated show, logos and designs that your art department might come up with. And we do searches in various different databases. We do keyword searches as well as reverse image searches, and we also search the trademark offices in Canada and the US and pull out anything that might be similar to the design that you want to use. And we would just flag that and let you know whether or not that might be okay to use. I think that covers what I was going to talk about, unless I'm forgetting anything, Amy, that you can think of.
No, I think that about covers it.
Yeah,
for the
yeah.
When you're working on projects, whether they're online, whether they're full for, a traditional film or television distribution, there are things in addition to the script report to sort of think about when you're creating your work, writing your work. If you're working for an art department and you're creating props or you're making designs, you're creating logos for things. I just wanted to go through some of the things that you sort of need to cast a clearance eye over or give a thought to. And clearances, as I mentioned before, are a bit like peeling an onion. There are many different layers. For example, if you're trying to get permission for a piece of stock footage or to use a film clip, many of us know that you need to get permission, or, sorry, I've just backed the track up a little bit, or you're trying to clear a record cover, a music record cover, or a poster for a room, a piece of artwork. Many of us know that you need to go off and get permission from the copyright or trademark owner to use that or incorporate that into your project. Quite a few people don't know that there could be third-party rights involved. So, for example, you're trying to clear a movie clip. You go off to, say, Universal Pictures to get permission to show a clip of this movie. In addition to that, there are other third-party rights that you also need to get permission for that Universal is not going to give you. Things like the actors' performances, music, any brands that are shown, payments to the Writers and Directors Guilds for the scenes that you want to use. Those are not included with your license with the original owner of the film clip. Those you need to go off and get separately. So contacting the actors' representatives or estates if they're dead, because just because they're dead doesn't mean it's a free-for-all. You still need to get permission from their estates. Things like CD cover or album covers. I don't want to say CD because that, makes everybody know that how old I am. But album covers, if you're going to a record company and getting, say, the Velvet Underground album that had the Andy Warhol banana on the front, you need to go to the record company to get permission to depict that album cover, but you also need to go to Andy Warhol's estate to get permission to use his artwork of the banana. So 2 separate clearances. So that's what I mean with the onion, in that you've got an onion and all of a sudden you've got all these different clearances once you get peeling that you need to worry about. So just going to list a few of them. Stock footage, film, we kind of went through. And no matter what type of work you're trying to license, whether you think it's public domain or whether you think it's royalty free or whether you think it's a stock clip, you always need to think about third-party rights, because even if your lawyer has said, yes, this is a public domain image or a public domain clip, or we've got a Creative Commons license, or we've bought it from a royalty-free stock company, they are only giving you the rights to the title of that piece. They're not giving you rights to third-party rights. So even though somebody said, it's public domain, you still need to go off and look at those third-party rights like actors and various other subsidiary rights. Other things to think of, books. If you're showing a book, or if you're reading from a book, the author typically owns the rights to the text of the book, and the publisher of that edition of the book typically owns the rights to the cover and the spine. So if you are reading from a book and you see the cover of it, you need to get both permissions, unless the publisher owns the rights to the text, but usually it's the author. And it's the publisher of the edition you're using, because of course, you know, for example, Agatha Christie has 500 different editions of her. You would need to figure out which one you're showing. Same with magazines. If you're showing a magazine and you're getting permission from, say, Rolling Stone to use the magazine, if you're showing pictures of celebrities or musicians or ads within the magazine, if somebody's flipping through it, or you see the back of the magazine with that big ad on the back, you need to get permission for those separately from the Rolling Stone permission. Same thing with posters. You see a Metallica poster, for example, you need to find out who designed that poster and get permission from them. And then you get to need permission from the band. And if they have any advertising promos on there, like sponsors logos, those need to be got as well. I find when one is shooting, teenager bedrooms are fraught with all of this stuff. Bars, for bar scenes, are really intensive with this type of stuff as well. Works of art, we touched on Andy Warhol stuff, but if you're using a work of art, they can also have third-party rights. For example, Andy Warhol's painting of the Campbell's soup can. In addition to the Warhol estate, you would need to get permission from Campbell's to use the soup can, or if it's his painting of Marilyn Monroe, you need to get permission from her estate as well. Sports footage, of course, most of this Major League sports footage is owned by the NBA and the NFL, the NBA, Major League Baseball. They're mostly the sports footage, the game footage is mostly owned by the federations, but you also need to make sure that if you get a license for this, the players, the uniforms, whatnot are included in that license. If you're showing the ads around the rink, for example, or around the stadium, those may need separate clearance if you're incorporating it into a piece of fiction. A lot of people say, oh, they want the advertisement, and they want the advertisement, they want the exposure, and that's certainly true. But if you're putting it into a piece in which you're editorializing around it, and it's fiction, and you're creating this scene around it that is different from the actual game footage, then those advertisers are going to want to have control over how that's depicted and the context around it. Pieces of choreography, are protected by copyright. Photos, if you're using a photo, getting permission from the photographer, or if you're getting permission from the photographer, but also anything contained within that photo. People, whether it's a celebrity or a private person, because in addition to rights of publicity and trademark that cover celebrities, rights of privacy cover normal people like you or I. And they all have rights that need to be respected. If you've got a picture of somebody and there's a piece of architecture in the background, or you're shooting along a street and you're shooting famous pieces of architecture, New York is a classic example, and famous buildings that have pieces of artwork attached to the building. Generally, you need to think about getting permission for those pieces of artwork, and I'll give you some examples of those. Again, stop me if you have any questions, or if I'm going too fast, or if you want to go off on another tangent, I'm happy to. But things like the lions outside the New York Public Library, you can photograph a copyrighted building if it's visible from a public space without infringing on copyright. But if that building is a trademark in and of itself, you need to get permission for that For example, the old Foldomat kiosks, where the kiosk was in the shape of the trademark, you would need to get permission to use that trademark. The Transamerica building in San Francisco, the building itself is a trademark for Transamerica. It's in the shape of the trademark, or the logo, so you would need to get permission to shoot outside of that because it has separate clearance issues. If you're shooting the Rock and Roll Hall of Fame, for example, hang on, I'm just going to shut my door here. Sorry, if you're shooting the Rock and Roll Hall of Fame, that building is so unique that it has a separate copyright. The lions outside the New York Public Library, if you've got a piece of stock footage and you see the Millennium Clock way back counting down on the Eiffel Tower, that's a separate trademark. The sculptures outside the Washington National Cathedral, for example. Recreating a photo is also could be problematic without permission. If you try to go after a licensed famous photo and you decide, no, it's too much of a pain to clear or it's too expensive, we're just going to recreate it, that's going to be a problem as well. You need to get permission from the original photographer or whoever owns the photo to recreate a photo. Couple of other things too while we're on the subject of photos. If or stock footage, don't change it unless you're given written permission. If you take a photo and you colorize it, if it's a black and white, if you colorize it, if you change it in some way, if you crop it, you need to get written permission from the owner because that will all be in your license, and they're very touchy about changing anything in their works. Other things to kind of look at with a clearance lens are sound-alikes. If you want a piece that sounds like a famous voice, like a Tom Waits or a Bette Midler, or you're really trying to, and it really sounds like that person, you need to get permission from the original. Because there have been several lawsuits brought about by specifically Tom Waits and Bette Midler, where companies have used sound-alikes to get around licensing fees, and they've been brought to court on it and lost significantly. And I have a bunch of those types of cases that I can get into the specifics of if anybody's interested. Computer software and interfaces, of course, need to get permission to use. If you have a character in a film that you're showing the Google screen, you need to get permission from that as well. Everything on the Google screen, if you've got ads popping up, those ads have separate clearance. Currency is another thing to be a little bit wary of if you are showing currency, especially close-ups. The U.S. Bureau of Engraving and Printing have very specific laws governing filming cash and coins. They're worried about counterfeit. The Bank of Canada has relaxed rules about showing currency, so generally you can show Canadian currency without any issues. Coins, Canadian coins, surprisingly enough, the Canadian Mint makes you get permission to show any Canadian coins in close-up. If again, it's a use your best judgment thing, in that if you can't identify something, if something can't be identified as being a Canadian coin, you don't need to worry about it. But if something is very obvious, that's what it is, then your lawyer may say, hey, this is going to be an issue. The other thing is, checks, bonds, stamps, documents, driver's licenses, passports, birth certificates. Aside, of course, you're going to be mocking up your own personal information on those, but any of those, if you're showing the front of a passport or an Ontario driver's license, the government has very clear guidelines on how those need to be depicted. Again, they're worried about counterfeiting. This isn't a copyright or trademark issue as much as it is a counterfeiting issue that they're worried about. Other things, if you are looking at a film scene or a television scene or any kind of scene, stamps, if you see a piece of mail and it's got a stamp on it, you do need to get permission from the US Postal Service or the Canadian Postal Service. If it's an Elvis stamp or something else on the stamp, that needs to have separate permission. All stamps post 1977 in the US are covered by copyright. In the US, anything pre-78, you're free to use. Again, third-party rights apply. So if it's a pre-77 Elvis stamp, you need to get permission from the Elvis estate, for example. If you are using any short phrases, those are protected both by trademarks and copyright. So just beware if somebody's off the cuffing real short phrases, like, again, I'm showing my age here, but, E.T. phone home, look up in the sky, it's a bird, it's a plane, it's Superman, here's Johnny. Any of those sort of phrases should send up a red flag. And you may not know what the red flag signifies, whether it's copyright or trademark, but your lawyer can help you walk through those, or a simple Google search can really tell you who owns the rights to that. Again, trademarks and copyrights, we don't need to get into the nitty-gritty of those unless somebody's really, keen on it. But if something can't be protected by copyright, it can be protected by trademark. And in general, copyright are at its very basic is the right to copy. So if you want to copy somebody else's work, you need permission. And copyright only exists in work that have been created in some tangible form. So copyright are works that have been spoken into a microphone or recorded into a recording device or written down or typed into a computer. Trademarks are words, symbols, pictures, designs, or the shaping of goods that are used to distinguish goods or services within the marketplace. So they're used to distinguish goods or services from one another within the marketplace. So you kind of need to think of both in the same breath when you're sort of analyzing what the scene is you're trying to clear. Celebrities have successfully proven that their name and likeness and signature are trademarks. So domain names are also governed by trademark laws as well. Some famous, the I Love New York sign. I'm just going to spew off a few. The I Love New York sign, the Hollywood sign, Beverly Hills sign, the picture of the scarlet-coated RCMP Mountie, those are all protected trademarks that need permission to be recreated in a fictional setting. Trade dress, the distinctive shape of the Coke bottle, the distinctive shape of a Pringles can are all examples of trade dress and protected. So if you're recreating the shape of a Coke bottle or a Pringles can, work with your lawyer to either get permission for that or change it in some way that is not identifiable with the original. Also, things like the front grille of a Rolls-Royce has been licensed as a trademark. The Harley sound, the sound of a Harley-Davidson motorcycle, has been successfully trademarked. Things like fictional characters, Tony the Tiger, Betty Crocker, Mr. Peanut, those are all protected trademarks. Music, just sort of jumping around here to another big one, is music. And a lot of people have questions about music because it's so complicated. And I would really recommend that if you are trying to clear music for your project, you get a music supervisor involved or you work with your lawyer to get clearance on music. And I'll just give you a very quick snippet on music clearances. When you're thinking about clearing a song, an original song, not one that you have recreated. There are two different quote unquote sides of music clearance. One side is the synchronization or publishing side, and that side covers the composer. So for example, Willie Nelson wrote Patsy Cline's very famous song called Crazy. So Willie Nelson would own the synchronization rights or the publishing rights to Crazy. The other side is the master recording side, and that is what the musician, the recording artist, records. So Patsy Cline would own the rights to the master recording. Where it gets complicated is that the Willie Nelson people have their own company, the Patsy Cline people have their own company, so you need to go to both to get permission for both sides of that. Where it gets even more complicated is if there are multiple writers. So the Beatles, for example, had two or more writers. And many songs have more than one writer, sometimes 5, 6, 10 different writers. And those writers could have all different publishing companies for each writer. So you would need to go to separate publishing companies to get permission for the publishing side of it for each writer that's involved. Generally, there is just one recording company involved in a master recording. But again, those are sort of the two sides. Many people also ask me, well, is there an 8-bar rule, or is there a rule of, a minimum amount we can use without getting clearance? And the answer, unfortunately, is no. If you're using just a sample of it or a snippet of a song, or if a character just says the words, says one sentence of a song, doesn't even sing it, just repeats it, you need to get a publishing license for that. And music is the one, the music owners are very, very strict, and they will go after people for doing that. So your lawyer and your insurance company will be very conservative in this, and they will probably have you either change it or get permission to use whatever piece of music that you're using, or snippet, or somebody just singing. If you have a character sing the song, for example, Patsy Cline has nothing to do with it. Now you want to have a character sing this Willie Nelson song. You still need to go and get permission from the publishing company to do that. You don't need the master recording anymore, but you do need the publishing. The other thing with music is if you're using stock footage, and CBC footage is really fraught with this, and variety show footage, anything sort of that uses a band or orchestra, you need to get a license from the American Federation of Musicians, because it's a union that covers the band and orchestra in those clips. So I cleared a clip of some variety show that the CBC did years ago. I mean, it was a 50s or 60s show. And we had to pay the American Federation of Musicians for each musician in that orchestra. And we didn't know how many musicians were in the orchestra, because it was, a 40-year-old clip, and all the records had been lost in time. So they just charged us a flat fee to use it, and not an insignificant fee. So again, just one of those invisible clearances to keep in the back of your mind. The other, while we're on the topic of invisible clearances, the other thing to think about are underlying rights. So some works that you use, whether it's a screenplay or a book or somebody's life story or a comedy sketch, have underlying rights. So if you have a clip of, say, the Perry Como Show from 1958, you're doing a documentary, or you're incorporating it into your project in some way, and there's a comedy sketch on there, that comedy sketch is not owned, and you've licensed this footage from, say, the Perry Como Show, the owners of that. The comedy sketch is not owned by them. The comedy sketch was written by writers who had licensed it to this variety show. There was a very famous case where Elaine May and Mike Nichols, A&E did this retrospective of the 50s. And they showed this Elaine May and Mike Nichols sketch from the Perry Como show. And they didn't get permission from Nichols and May to use it in addition to licensing the Perry Como show. And they got sued for using it. Movies like It's a Wonderful Life are in public domain in North America, but the underlying screenplay, the underlying story is, the underlying story isn't, but the music is still protected. And anybody who's seen it knows that it's mostly a musical show, a musical film, and there's music everywhere. So that's how the studio controls it. So you can use It's a Wonderful Life without paying, but you can't use any of the music. Again, the actors' performances you'd still need to get permission for, and so on and so forth. Another example of that is the George Bernard Shaw play Pygmalion. This was made into a movie in. This was made into a movie. The underlying stage play was still owned by George Bernard Shaw, and the movie fell into the public domain. So people could still use the movie without getting permission from the film's owner, but they had to go to George Bernard Shaw's estate to use the underlying play because it was still protected by copyright. So just a quick 411 on that. The other quick thing to go through is something called moral rights, which if you've licensed a piece of an artwork or a piece of a painting or a sculpture or any piece of art for your show, moral rights protects an artist's integrity of their work. So for example, several years ago, I don't know if anybody knows, most of you probably do, the Canada Geese in the entrance of the Eaton Center is a Michael Snow piece of artwork. And one Christmas, the Eaton Center decided to be festive. They would put bows around the geese's necks, red bows tied around their necks. And Michael Snow, the Eaton Center, no, this is a conflict of my moral rights. I don't want the bows on the geese. That's not what it was intended for. You have to take them down. And the Eaton Center by law had to take down the bows. So that's just a small example of moral rights. So again, if you have licensed a piece of artwork or licensed anything, don't add anything to it, don't take away anything to it without written permission. And that's kind of bringing us to the end of the different things. Just whatever you are looking at, if you're working in an art department, if you're doing your own thing and you're bringing in outside pieces of work instead of creating them yourself, just keep in mind these layers, whether it's a graphic you're creating, whether, props you're creating, just keep these in the back of your mind. When you're filming, I get another question before I sort of wrap it up here and take questions, because I know we've only got a few minutes left. Another good question I get is, when I'm filming a street scene and we are motoring down Yonge Street and it's a chase scene, or we're just driving down a street and you see stores along the way, you see street signs, you see Coke signs in the windows, you see other cars which have brands associated with them. What are the sort of legalities with filming that? Obviously, if I'm just driving down Yonge Street, I'm not going to get every sign and permission for every sign. It would just be a ridiculous endeavor. It would take too much time and too much money. And this is something you're going to work with your lawyer on. And what we've learned as researchers and working with lawyers and working with insurance companies over the years is that most lawyers or insurance companies are okay if you're filming a street scene and you're driving down the street and you are just driving quickly by these businesses and these brands. Yonge and Dundas Square is a classic example. And you're just driving by them. Nothing is focused on. There's nothing, you're not blowing things up in front of a MaxMart. And then they're generally okay with you assuming the risk of not getting permission for anything. If you stop and all of a sudden you're in front of a 7-Eleven, or if you're in front of a Artesia store, now they're going to say, now you've stopped, now the scene is in front of this store, you're focusing on them, it's a bigger risk, you should go and get permission to use this store. Or if something not questionable, but something that, something being blown up, or there's a crime being committed in front of a brand, or you see a Coke sign in a window and you can't see the business, but you can see the Coke sign, you better get permission to use that Coke sign, for example. Those are the sorts of things that lawyers and insurance companies are going to get very nervous about. And that's kind of where we found their parameters are with that sort of thing. Again, it's a matter of working with your lawyer on that, because they're going to be working with your insurance company. And if you don't have an insurance company, they're going to be working with whoever your distributor is to assess what their risk level is. So that's kind of it. Are there any questions about anything that we've talked about? Anything? I'm just going through the questions here, and I don't know if any of them for us, but please let us know if you have any questions, and we'd be happy to answer them. Otherwise, Rodney can come back in and moderate things. And if anybody wants to chat with us after the fact, we're happy to stay and chat after the fact. Do you have anything? Do you have anything that I missed, Shannon?
No, I think you did a great job of covering everything. I think there's one question maybe at the end here for us, the very last couple of questions here from Samantha, if you can see in the Q&A.
Yeah. I worked for a clearance company in Vancouver. Good times. Come across a lot of fun information. Yes, it's a trivia. Shannon and I are trivia queens. I don't think there was a question there.
No, it's in the under Q&A there.
Yeah, my
apologies.
Yeah, Samantha asks, at the company I worked at, sometimes we'd get finished content to clear, which can be frustrating for all involved. When do you recommend filmmakers first contact a clearance company?
Oh, that's a great question.
Yeah.
Shannon, let me throw this over to you and let you answer, because Shannon's the one that is our sort of traffic cop with reports.
So normally the script comes to us fairly early. We need enough time to clear the names and make any changes that might be needed to character names. So you need to give yourself enough time to deal with anything like that that's going to come up. If your main character's name doesn't clear, you need to come up with something that you like. So we often go through various revisions as well. We usually start out fairly early on a script, and then we'll get the revised scripts as well to just go over any changes that have been made and to clear that type of work as well. Does that answer the question?
There's a couple other questions here. Just scrolling up. My apologies for missing those, which I'll just go through really quickly. From Crystal, are you open to multi-platform concepts for instance? Absolutely. We do a lot of web series. We do a lot of YouTube stuff, actually, especially animated YouTube stuff, which is super cute.
Amy, those were from the previous panel.
Oh, they were. Well,
yes.
That answered their question. My apologies.
But if there's something you want to tackle, knock yourself out.
No. Well, I think I just answered the question, but we do all types of projects, including video games. We have video games because they, even if your insurance company doesn't require it of you as part of your errors and omissions insurance package, then it's a really good preventative thing, because even if it's a situation where somebody says, this is ridiculous. I would win this case in court if needed. It's not a matter of whether you'd win a case or not. The expense of going to court in the first place, and defending yourself against even a small owner, not a Disney or a Universal, is so expensive. It would sink any small Canadian producer. So be really conservative. Canadian lawyers are pretty conservative about that. So Samantha just said, by finished content, I mean already filmed projects without the scripts being cleared first. We typically do. We have done that. We always work on the script, though. We don't work on the finished video content. So people will sometimes send us scripts after it's been shot and say, we need this for our insurance. And we just work with them back and forth on that. And we certainly will do that. As soon as you can, when you've been greenlit and you've gotten your script to a reasonably okayed stage by the distributor, send it along to us. As long as you've got the time, our turnaround times typically, say for a feature film, is 7 business days from when we get the script to when we turn around a report. And then if some of your names don't clear and you need to change them, for example, if you've got a fictional character named John Duncan and he's a lawyer in Toronto, and we find a real lawyer in Toronto with that name, then you need to change the name to something that doesn't exist, or so many of them exist that it's now not a conflict with any one of those real people. You're going to need some time after that for us to go back and forth and find a name that does clear and that your lawyer is happy with. Does that answer your question, Samantha? Carrie just said, I came late, so I might have missed you if you covered documentaries using clips for fair use. For example, a documentary critiquing media on a topic using clips from media examples. Another great question, and I have a whole other fair use could take up an entire day. So I'll just give you the 411, Carrie. Fair use is a judge-made concept, just for people really quickly, I know we don't have a lot of time here, is a judge-made concept that to foster the creation of new works, the copyright law has an exemption that allows for works to be used without permission in limited circumstances. Fair use is not applicable outside the US and Canada, so if you have a documentary you want to distribute worldwide, you're out of luck. It's a judge-made concept, and it's only a defense when legal action is taken. So it's not a preventative magic bullet. So Carrie, if you are working on documentaries and you are selling this documentary to a distributor and you're making money on it, and I appreciate you're probably not making a lot of money on it, but you are quote unquote selling it, then fair use will probably not fly, even if you are critiquing media use on the topic. So, for example, if you want to use, for example, and fair use is very limited. It's for the purpose of research and private study. And let me just I'm just bringing myself back up to speed a little bit. But it is a defense in case you are sued. So the only time you'd be able to use it is if you were, God forbid, sued over something. And then you could use it as a defense, but only in very limited circumstances. And generally a documentary that's being sold to a distributor or a broadcaster or to a streamer is not, will not fall under fair use. So I have a lot of information, Carrie, My email is amy@therightscompany.com for anybody who wants to email me for more information. I have lots of information on fair use and public domain and Creative Commons and all that. Feel free to email me for more information. I'd be happy to send it to you. Felicia, all my work is done with fake sets, stock images that I buy at the internet. My series pokes fun at these images. I buy them, pay for them. Should I be concerned about using them in my web series? That is a question for your lawyer. And I'm sorry to throw it back to the lawyers, but I'm going to tell you why. When you buy a stock image, your lawyer, it comes with a license agreement, and just like a traditional, licensing scheme would. It comes with a license. Generally, licenses are okay with you poking fun at images. Now, if it's an image of Jennifer Aniston and you're poking fun at Jennifer Aniston, now we have a problem. Now it's not okay. If they're just generic images, it might be okay. But again, it's a question for your lawyer, because it depends on how you're poking fun at them. And it depends on the context surrounding these images and how they're being used. If it goes from poking fun into more of a malicious application, and I know that that's a very subjective thing, then your lawyer and your insurance company might put the kibosh on that. So that is very much a piece by piece thing you need to analyze with your legal counsel on that. And I think that's all the questions, unless anybody else has any questions. And if not, please, we're going to stick around afterwards. But again, please feel free to email myself, amy@therightscompany.com, or Shannon@therightscompany.com for any more information you want on specific topics or niche topics.